Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Listen, the 10th Circuit has gotten a lot of attention in the last couple of weeks, one with a big ruling challenging New Mexico's waiting period, but we're going to circle back on a different ruling that came out a couple of days ago that has a very, very dangerous rule of law to it. Now, this deals with a challenge to the prohibitions against cannabis users possessing firearms. We're not going to really get into that issue. We've covered that issue enough. But I do want you to know that a 3-judge panel of the 10th Circuit has sent this back down to the trial court, disagreeing with its previous findings and announcing a new rule of law here that is, well, candidly could disarm just about anybody. And I'll explain it all in just a moment. So today, let's spend a few minutes and let's talk about an immensely dangerous ruling from the 10th Circuit. Okay, America, we are talking about a case that was just decided by a 3-judge panel in the 10th Circuit and is now going back down to the district court for further findings. The case we're talking about today is the matter of United States v. Harrison. It is a challenge to 18 United States Code Section 922G3, which is the prohibition on cannabis users possessing firearms. We don't need to go over the facts. You guys know the facts. Harrison gets busted both with evidence that he's using marijuana and a firearm. He challenges the constitutionality of the law. The lower court, the district court, actually finds that this law is unconstitutional as applied to him. The United States government appeals to the 10th Circuit. 3-judge panel hears it and says, not so fast. We're going to send it back down. And this is what I want you to be aware of, is although the court did a really good job of narrowing the issue here, they came up with an immensely broad rule of law and sent it back down to the trial court, which candidly, if this rule of law were to become commonplace in Second Amendment litigation, it would literally allow the preemptive disarmament of any group that local politicians believe ought to just be disarmed. Now, here's what happened at the lower court. On February 2nd, 2023, in a thorough 54-page order, the district court granted Mr. Harrison's motion to dismiss. The district court held the Second Amendment's text covered Mr. Harrison's conduct because he is among the people to whom the amendment refers. The court further held applying Section 922G3 to Harrison is inconsistent with the nation's historical tradition of firearm regulations. Okay, so we were off to a good start. Now, I said that the court really did a good job of narrowing the issue, because the issue, as announced by the court, and this is correct, is, we therefore conclude this case presents a challenge only to Section 922G3's application to non-intoxicated marijuana users. Okay, so this is not a challenge to can you possess a firearm while you are high on weed. And there is a long, rich historical tradition in this country going all the way back, even predating the existence of the Second Amendment, that has allowed government to disarm individuals who are actively intoxicated, okay? That is not the issue. There was no allegation that Harrison was high at the time they found him in possession of a firearm. But even though the court found that Mr. Harrison was part of the people, which he is, they disagreed with the final historical analysis, and ultimately the 10th Circuit is going to rule, we endorse much of the district court's analysis and reasoning. At Bruin, Step 1, we fully agree with the district court that the Second Amendment applies to Mr. Harrison's conduct. At Bruin, Step 2, we agree with the district court in part, as we will explain. Oh boy. That's not good. Where exactly is the 3-judge panel of the 10th Circuit going? Here. We then move to the heart of Bruin Step 2. We ask, has the government shown that Section 922G3, as applied here, is consistent with the principles that underpin our regulatory tradition? The district court answered no, but as we will explain, we ultimately conclude otherwise. Now, ultimately, the government tried to justify this both under laws involving people who are actively intoxicated, as well as anyone who uses a controlled substance is akin to being mentally ill, and for that reason, they can also be disarmed. The 3-judge panel of the 10th Circuit was not convinced there because they ruled, we agree with the district court and Mr. Harrison. On the record before us, the government has not shown laws disarming the mentally ill are relevant historical analogs. So where then is the danger in this ruling? Where is it coming? Well, it comes from this, is that we do have a historical tradition of disarming Catholics, and loyalists and things like that. And even though they had absolutely demonstrated no propensity for violence whatsoever, the mere fact that some people suspected them of potential violent behavior in the future was enough standing alone to disarm them. That leads this three-judge panel to rule. We now turn to the second historical principle the government identifies to justify Section 922G3. According to the government, historical regulations reveal the principle that a legislature may disarm those believed to be dangerous. Think about that term right there. Believed to be dangerous. Not actually dangerous, not proven to be dangerous, not previous acts show that they are in fact dangerous, but merely believed to be dangerous. And the three-judge panel goes further. But as we will explain, the government has identified historical analogs that reveal another key principle underpinning our nation's history of firearm regulations. Legislatures may disarm those believed to pose a risk of future danger. We thus agree with the district court about one reason why our predecessors disarmed certain individuals to prevent dangerous people from possessing arms, but disagree about how they made those determinations. They looked both backward and forward. Check that out. We could not only look back and see what their actions were, which I think is a pretty objective criteria to use, but we can speculate as to what we believe their actions may be in the future and use that as a form of disarmament. And as I mentioned earlier, even though the court may have narrowly tailored the issue itself, well, they've come up with a very broad rule of law. Those historical restrictions swept broadly, disarming all people belonging to groups that were, in the judgment of those early legislatures, potentially violent or dangerous. Now, where could the possible historical justifications come from? How could you possibly connect all of those dots? Well, it's another installment in
You got Rahimi'd.
Because the 10th Circuit three-judge panel has ruled, following Rahimi, we must answer in the first instance whether it is consistent with the principles that underpin our regulatory tradition for a legislature to disarm those it believes to pose a risk of future danger. Turning to that question, we agree with the government that the answer is yes. And of course, the laws that were relevantly similar for this more nuanced approach that kind of puts us in the ballpark of where we need to be. Yeah, that's the laws that disarmed the Loyalists and the Catholics and the Native Americans. And ultimately, this three-judge panel has ruled, we join others in using colonial laws disarming Loyalists to discern our nation's historical tradition of gun regulations. The colonial laws manifest a why, preventing dangerous people from possessing firearms, that aligns with the district court's reasoning. But these laws also reflect a how, legislatures disarming those believed to pose a risk of future danger, which is broader than what the district court allowed. Now you sit there and you go, wow, that is a pretty open-ended, vague criteria to disarm people. It's a little overgeneralized. We think they maybe might pose a risk of dangerous activity in the future. Where again would the justification for that come from? Well, once again, with the guidance of Rahimi, we land closer to the government. Determining the level of generality at which to define historical principles is no easy task. Yes, you see, but it becomes much easier when we want to employ Rahimi to its fullest extent and just be in the ballpark, or not even in the ballpark, but in the parking lot next to the ballpark, which will lead a three-judge panel of the 10th Circuit to rule, we thus conclude laws disarming Catholics and Loyalists reveal a tradition of disarming those believed to pose a risk of danger, regardless of whether the perceived danger is related to waging war. Or put other ways, regardless of whether or not they've actually engaged in unlawful or dangerous activity. This is a standard that would be so abused, especially by the states right here on this list, or by the federal government when it changes its political winds, which it will inevitably. This literally allows a preemptive disarmament almost through like a minority report type legislative scheme. So, what has the 10th Circuit done here? Well, they're sending the case back down to the district court for further findings. The specific order of the court reads, accordingly, in this case, the district court should have inquired into whether the government could justify its assertion that non-intoxicated marijuana users pose a risk of danger. And we further hold the district court must inquire into the government's assertion that non-intoxicated marijuana users pose that risk of danger. And so the case goes back down to the lower court. But I want you to think about the inherent danger in this rule of law. The government may disarm groups of individuals that they believe might be dangerous, might be potentially dangerous, might pose a risk of dangerous activity. What exactly defines that? Because right now, the 10th Circuit has divorced that inquiry away from actually taking a look at their previous actions. This is all based upon somebody's speculative and or subjective opinion of that group. And one need not a very vivid imagination to understand how this could be abused by both sides. And for those who are normally clamoring for civilian disarmament, I will point out right now that there is a group of individuals in this country who are beginning to show a very, very dangerous propensity for violence merely by possessing firearms, and perhaps there should be a discussion about all of them being disarmed. But at the end of the day, America, if we're going to disarm groups of individuals because we believe them to be dangerous, the only objective criteria that we can use is that they have actually engaged in dangerous activity. But the 10th Circuit has completely abandoned that principle, and this, my friends, leads to very, very dangerous precedent. We're going to have to very carefully watch this case. Okay, the case once again is United States v. Harrison. We're going to link it up down below so you can see the ruling of the court yourself. Maybe you got questions about this or anything else related to what's left of our Second Amendment rights. Now, if you guys do, you should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.